Good morning, sir. You Brian McWade?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Yes, Your Honor. We're pleading to the lesser included attempted.
Thank you.
Just need to see, make sure that.
Okay, I'll be sure to add it.
Mr. McWade, in cause number 26 DCCR 0402, the state has elected to proceed on the lesser included offense of a third-degree felony, attempted aggravated assault with a deadly weapon, from March 8th of 2026. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Macon?
Yes, ma'am.
Do you fully understand them?
Mhm.
Yes or no?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for an 8-year deferred probation. No, I'm sorry. There would be an 8-year term in prison that would be probated.
Which I
for
believe
8
we can
years.
do since it's an attempt, Your Honor. Typically with this offense, you
Right.
can't, but I think since we made it an attempt, we're okay.
Okay. Y'all looked at it
A
a little bit?
little bit, yes, Your Honor. That's
Okay.
my understanding.
All right. So what we'll do also is between now and sentencing, if everybody will double check, just so that we make sure before sentencing that we don't do something that we're not supposed to.
It's in that big green book, I think.
I'm sorry.
It's in that big green book.
Yeah.
The big green
The
book.
big green book. All right. So it looks like the agreement is for you would be convicted with an 8-year term in prison. That would be probated for 8 years. There would be a $1,000 fine, and you would be required to follow all of the rules and conditions of probation. It's checked off restitution center,
There is restitution involved, Your Honor.
but not the restitution. We don't even have that anymore. We need to change that. We don't have a
Saw
restitution.
the word restitution and checked the box.
So there's an agreement. I'm going to write that you would pay restitution. Is that correct? And the amount determined between now and sentencing?
Yes, Sean.
Is that, you understand that as well? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection, Your Honor.
It's admitted. Is there any evidence that Mr. McWade's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back for later for sentencing. That'll also give everyone an opportunity to figure out that restitution amount, and we'll double check that based on what the nature of this offense is, that we can do that convicted probation. I want everybody to double check that as well. So with regard to a bond based on the nature of this plea agreement, Mr. Nichols, what's the state's?
Your Honor, he served 150 days in jail. For this case, we don't propose a bond pre-sentencing.
So, Mr. McWade, what I'm going to do in your case, based on the nature of your plea agreement, is reduce your bond to $1,000. If you make that bond, there's a couple of things that are very important. The first is that you go directly to the probation department when you're released so you can get that pre-sentence report done. If you don't do that, you run the risk of me not accepting the plea agreement, and things could be worse. Also, if you are arrested for anything between now and when you come back for sentencing, you run the risk of me not accepting the plea agreement. And then the last thing would be, a condition of your bond is that you have absolutely no contact or communication with Simone Mullins. That's obviously communication in person, but it's anyway. You can't send messages through any type of social media or other people or anything like that. If you do, and I find out about it, then your bond will be raised, you'll be back in jail, and I probably won't accept the agreement. All right, any questions? All right, good luck to you, sir. You can go back with the bailiff. We'll see you at sentencing.
Thank you, Your Honor. Let's make it.
Could you please make? Good morning, you're Brendan Ernest. And Mr. Ernest was previously in court. Look at this way, pay attention to me. In cause numbers 26 DCCR 0429, 0430, and 0908, entered pleas of guilty to aggravated robbery, obstruction or retaliation, and robbery. I've received the pre-sentence report. Have y'all both had an opportunity to review that report?
We have, Your Honor. Yes, sir.
In addition to that, I've received and reviewed jail incident reports. Have y'all had an opportunity to review those?
We have. Yes, Judge.
All right, I am not inclined at this time to accept this plea agreement, based on the information of the offenses themselves, as well as the additional information that the detective has relayed with regard to all of the things that Mr. Ernest has been involved in, as well as what he's doing out at the jail. So y'all want to talk to me about
And
how to
Judge,
change my mind?
I don't know that this is going to change your mind, but I meant to object to the part of Officer Jackson's statement as far as any uncharged conduct that happened while he was a juvenile in 2023.
I think that it's relevant and it's information that's important for me to know. If he's had contacts just because he was a juvenile and certain people didn't follow through because he was a juvenile and wanted to give him that opportunity, I don't think he gets to now say, well, I didn't get in trouble. So, because somebody was nice and gave him some opportunity back then.
Well, then what I would say, Judge, is this is a youthful offender. He's 17 years old. These are his first cases. Some juvenile history that like it was successful completion of probation. He's never been on probation as an for either a felony or a misdemeanor. The alternative, Judge, I know is prison. And certainly there's a lot of violent crime going on in our community. It's for a first offense. I have a hard time sending people to prison for their first offenses, even though these are serious offenses. Some of them do deserve to go to prison for their first offense, but a 17-year-old first contact as an adult, I would ask the court to consider following the agreement with some sort of, I know the probation recommends MRT. I've also talked with Mr. Ernest about ISF, and he's
There
willing.
you go. He's 17.
Yeah.
So here's my thought on something like this, based on the nature of these offenses and based on what he said to the police that day, which gives me a huge amount of concern. I'm not going to repeat the words here about what he said he was going to go back and do to that clerk. I'm not letting him out on today. Not doing it. If a jury wants to do that, I'm not one to throw things on y'all know how I am about my trial docket. I'm not inclined to just throw things on the trial docket, but I think this is one for the community of Jefferson County to decide instead of us, because I'm not going to give them probation. If they choose to do that, then that's going to be up to them. But I don't think this is in any way someone deserving of probation, regardless of his age, at least at this time. If he had been not acting like a fool in jail, maybe I'd decide differently. But he hasn't changed anything. You haven't changed anything. I'm talking like you're not here. You haven't changed anything about your behavior. You're out in our jail, acting like an idiot with the rest of the youthful people out there, doing nothing but giving those people that are going to work every day crap. And if you think that's going to get you somewhere and you're going to get to go home today, now you see what it's going to do. It's not. You're going to get set for trial. And when you come to trial, if you're found guilty of these offenses, a jury's going to get to see all of that information about how you're acting at our jail. So you need to keep that in mind between now and when you come back to trial, because if you're going to be asking a jury to give you probation and you've been acting like this, highly unlikely. All right. So what I'm going to do is I'm going to set it on the trial docket. Mr. Ernest, Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and I'll appoint another attorney today who can begin preparation for trial a little quicker. Is that okay with you?
My decision.
Yep. If you want to keep Mr. Rojas, you can keep him. If you want to get someone else, you can ask for that as well.
Okay.
All right. So Mr. Rojas will begin preparation for trial. And, there's things, if y'all want to go to a jury for punishment only and accept responsibility, that's an option, but talk to him about that. But I'm not going to do it. All right. Thank you. I appreciate what y'all did. And I don't like getting involved too much in these negotiations,
The offer was obviously made because of his age.
Sure. No, I completely understand that. And I know you didn't know probably all the information, Mr. Smith, once it came out in the pre-sentence report about some of the specific facts of the case, as well as some of that history that gives me concern, as well as this jail stuff. So, I'm not saying you shouldn't have given the offer. I'm just saying there's a lot of things you probably didn't know as well. So, all right, go back with the bailiff. Mr. Jones, in cause number 26, DCCR 0842, you're charged with the state jail felony offense of theft with previous theft convictions, and that's from March 13th of 2026. Your indictment alleges that you were previously convicted of theft February 8th of 2012, and then again June 3rd of 2013. And how do you plead to that charge?
Yes.
Not guilty?
Guilty.
Guilty. And are those prior convictions true?
Yes.
Did you enter your plea of guilty and true freely and voluntarily? And did you plead guilty because you actually did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Jones is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find those 2 prior convictions true, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of theft with previous convictions, sentence you in accordance with your agreement to a term of 6 months in the Jefferson County Jail under Section 1244 of the Penal Code. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you did waive your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas.
Yeah.
All right. Good luck to you, sir. You can go back with the bailiff. And then you've got Lorenzo Thomas.
There's some new offenses.
We just need to put some time. Okay.
I just want to let you know what all it has in addition to the motion.
Okay.
Decide if we were just going to stay or go elsewhere.
Good morning, sir. Are you Lorenzo Thomas?
Yeah.
And this is cause number 2240120. And Mr. Thomas is on probation for aggravated assault with a deadly weapon. And there's a motion to revoke that unadjudicated probation. What is the announcement?
Judge, it's come to the attention of the state through Mr. Burrell that the defendant has, in addition to the Jasper County cases alleged in the motion, a new offense of evading detention felony in Harris County. I believe felony, Harris County. There's an active warrant for that now. I can either file a first amended motion to include that now that we have that offense material. We can allow him to go on that warrant, whatever the court wants to do, or go through this motion and see where we are. And I can still add it, but we kind of know where we were, whatever you want me to do.
I mean, I guess if it is going to be the state's position based on all of that for me to revoke the probation, then I think I need all the information. Okay. So first amended would probably be the best way to go. I know getting officers from Harris County might be difficult, but my thought is let's get it filed.
Okay.
Get an offer, get whatever discovery materials you can get on that to Mr. Rojas. If there's an agreement at the next court date, great. If not, so we'll get pleas of true or not true and then set a hearing and see who you can get to come. Possibly, and if there's an agreement to take any witness on Zoom, we can still do that, especially on these hearings. But if that would be up to Mr. Rojas, you guys, and I'm not trying to press you to do it, but y'all can visit about that. If that's an option, we can take some certain things up that way as well.
Sure, I'll get it filed this week.
Perfect. All right, we'll just do a reset then for that. Thank you, Mr. Burrell. It's good to see you.
Thank you, Judge.
All right.
Oh, who's this?
Christina Rodriguez. This is Miss French. Good morning, ma'am. You're Christina Rodriguez.
Good morning.
And this is cause number 17-27256. I'm going to take judicial notice of the court's file. Do you have paper there?
We're gonna go through the motion
Okay.
in a second.
And in the file, Ms. Rodriguez was examined for competency to stand trial by Dr. Capon. I received that report dated June 22nd of 2026. The finding in that report is that Ms. Rodriguez is currently competent to stand trial. Is there any other evidence with regard to competency?
No, Your Honor.
No, Your Honor.
Then at this time, I am going to find Ms. Rodriguez is competent to stand trial. We'll move forward and will she waive the formal reading of the motion?
Yes, Your Honor.
And Ms. Rodriguez, did you swear her in?
Yes.
Okay. Even if, usually you don't if there's no paperwork, so I was just making sure.
Right.
Gotcha. Thank you. Ms. Rodriguez, in clause number 17-27256, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 16th of 2018 for injury to a child, elderly, or disabled individual, a second-degree felony, and that was a 10-year deferred probation. Is that correct?
Yes.
This motion alleges that you violated your probation. Count 1 alleges that you committed the new offense of terroristic threat, October 23rd of 2025 in Orange County, Texas. And is that true or not
That's
true?
not true.
Count 2 alleges that you committed the offense of harassment on October 23rd of 2025 in Orange County, Texas. And is that true or not true?
No, that's not true.
Count 3 alleges that you failed to avoid injurious or vicious habits as directed on December of 2025. You disrupted and created disturbances at the Tiger Hut in Silsbee, Texas by calling, harassing, threatening, and posting falsehoods on their business website. Is that true or
That's
not true? Count 4 alleges that you're behind in your court assessed fees as of March 26th of 2026 in the amount of $9,198.39. Is that true or not true?
That's true.
All right, then, did you enter your plea of true to count 1 freely and voluntarily? Count 4 freely and voluntarily. And did you plead true to that count because it's actually true?
That's true.
Then at this time, I'm going to find count 4 true, find that you entered that plea freely and voluntarily, reset your case for a sentencing hearing. We'll get an updated pre-sentence report done. Ms. Malfino,
Judge, Ms. French has a detailed witness list already prepared. I'll make sure that it goes out whatever date the court gives me today. And if she's in trial on something else, I'm paying.
so that'll probably need to have a little bit, a couple of hours, I would think, not just a short.
Like maybe you have 4 witnesses.
Okay, so we'll get it set on a date when we have plenty of time. Anything that you think is important for Ms. Holmes to know, get that information to her. She'll present it to me on your behalf when we come back and we'll set it for a hearing.
Yes, ma'am.
Okay, you can go back with the bailiff.
Okay.